Judge, just a couple of things for the record, if I can. We would renew our objections done in chambers regarding the jury. We'd also renew our request to allow Dr. Diamond to testify. We also would renew any other motions and requests we may have made pre-trial for the court to reconsider those.
Okay, and I would stick with the same rulings. So.
And the last thing is, Judge, I know that we discussed this the other day. There's a camera in the courtroom, which we object to. But I'd like the court, when the court sequesters the witnesses, to make sure that they're made aware that they can't be watching live feeds of this trial, or anybody in the courtroom cannot be watching it either.
Okay, that's reasonable.
Your Honor, one thing I'd like to mention is there's a couple of witnesses, one that I mentioned,
yes,
a Jody Altman, and one that defense counsel had mentioned as well, Rhonda Jewell, that are not going to be witnesses in this case that we've said that could actually be in the courtroom. They've been instructed they cannot discuss whatever they see in the courtroom, but we wanted just to make a record of that.
And that's correct, Judge.
Very well.
And can the court go ahead and instruct the witnesses that are going to be testifying today?
Yes, if they're in here.
And Tim Griffin, and Tim Griffin.
Yeah, because he's not.
What just happened? It's just saying, normally we sequester the witnesses.
Yeah, then no.
That's wrong. Yeah, he still said that.
He's going to expect us to tell each other.
Okay, we got everyone that we needed to. Speaking to you folks that are prospective, excuse me. Speaking to you folks who are prospective witnesses in this case, I need to instruct you right now that you are not to discuss this case with anyone other than the attorneys. If any of the attorneys should come to talk to you, you should certainly discuss it with them. You are not to watch, read, or listen to any media accounts regarding this trial. That would be television, radio, newspaper, print, whatever. Do not view those. And then finally, there is also a live view or a live stream viewing on television of this trial that will take place. You are instructed specifically that you are not to watch or listen to any of that live streaming television. Any other instructions desired of these witnesses at this time?
No, sir.
Okay,
no,
fine. If you'll, Mr. Bailiff, if you'll escort them back to from whence they came. Okay, are we ready for the jury?
Yes, Your Honor.
Yes, sir.
Okay. If you'll show the jury in, please, sir.
Some in the back. All rise for the jury. All jurors present.
Be seated, please. Now, members of the jury, now that you're seated, I'm going to ask you to stand again, and we're going to swear you in. At this time, if you'll please stand and raise your right hand. Madam Clerk, if you will administer the oath, please.
Do you solemnly swear or affirm that you will well and truly try the issues between the state of Florida and defendant Rhonda Jewell, whom you shall be in charge, and render a true verdict according to Yes.
Fine. Have a seat, please. Members of the jury, as you now know, you have been selected and sworn as the jury to try the case of the state of Florida versus Rhonda Jewell. This is a criminal case, as you also know. The defendant, Ms. Jewell, is charged with aggravated manslaughter of a child, third-degree murder not premeditated during other felony, and 3, leaving a child unattended in a motor vehicle with great bodily harm. It is your solemn responsibility to determine if the state has proved its case beyond a reasonable doubt. Your verdict must be based solely on the evidence or lack of evidence and the law. It is the judge's responsibility to decide which laws apply to this case and to explain those laws to you. It is your responsibility to decide what the facts of this case may be and to apply the law to those facts. Thus, the function of the jury and the function of the court are well defined and they do not overlap. This is one of the fundamental principles of our system of justice. All cell phones, computers, tablets, or other electronic devices must be turned off while you're in the courtroom. You've heard this yesterday and day before yesterday, but it needs to be repeated. Turned off means exactly that, turned off, not placed in a silent or vibrating mode. You may use these devices during recesses, but even then, you're not to use your cell phone or other device to find out any information about the case or communicate with anyone about the case or the people involved in the case. You are not to take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure that your cell phone or electronic device is turned off. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have the opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you should not consider it as such. Following the opening statements, witnesses will be called to testify under oath. The witnesses will be examined and then cross-examined by the attorneys. Documents and other exhibits may also be produced as evidence. After the evidence has been presented, the attorneys will have the opportunity to make their final arguments. Following the arguments of the attorneys, I will instruct you on the law that applies to this case. After the instructions are given, then you will retire to consider your verdict. If you would like to take notes during the trial, you may do so. On the other hand, of course, you're not required to take notes if you don't want to do that. That will be left strictly up to you. You will be provided with a notepad and a pen for use in taking notes. Any notes that you take will be for your personal use. However, you should not take them with you from the courtroom except when you retire to the jury room to deliberate your verdict. During recesses, the bailiff will take possession of your notes and return them to you when we reconvene. After you have completed your deliberations, the bailiff will collect and destroy your notes. No one other than you will ever read those notes. If you do take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as an aid to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of others. Notes are not entitled to any greater weight than each juror's memory of the evidence. You should not form any definite or fixed opinion on the merits of the case until you have heard and received all of the evidence, the closing arguments of the lawyers, and the instructions on the law by the judge. Until that time, You should not discuss the case among yourselves. The case must be tried by you only on the evidence presented during the trial in your presence and in the presence of the defendant, the attorneys, and the judge. Throughout this trial, whether you're in the courtroom, jury room, recess, at home, wherever, you are bound by the following rules. 1, do not communicate face-to-face, electronically, or otherwise about this case with anyone, including fellow jurors, family members, and friends. Do not talk to the attorneys, the defendant, or the witnesses about anything. Do not allow anyone to talk to you or in your presence about the case. If anyone tries to talk to you about the case, tell him or her to please stop because you're on the jury trying the case, and if that person should persist in doing so, leave the area and report the matter to the bailiff at your earliest possible convenience. Do not visit any place described in the evidence. Do not read, watch, or listen to any media accounts of this case. Do not do any investigation or research, manually, electronically, or otherwise, about the law, about this case, or about the people involved in this case. After each recess, again, please double-check to make sure that your cell phone or other electronic device is turned off completely. You ought to understand that instruction by now. We've done it how many times? Any juror who violates any of the rules that I've just stated to you jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court or face other sanctions, such as serving time in jail, paying a fine, or both. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections which they feel are proper. When an objection is made, you should not speculate on why it was made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary for me to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. When possible, these conferences will be conducted here at the bench, and you can remain in the courtroom. However, sometimes it might be necessary to have you retire to the jury room while we confer. It's impossible to predict when such conferences may be required or how long the conference will last, but when we do have them, I will assure you that we will conduct them to consume as little of your time as possible. Does the state wish to make an opening statement?
Can we approach this for a moment?
Very quickly. Is the state ready to proceed with its opening statement?
Yes, Your Honor.
You may proceed.
May it please the court, counsel? Good morning. As you've been told, the defendant in this case has been charged with 3 different crimes: aggravated manslaughter of a child, third-degree murder unpremeditated, during the course of a felony and leaving a child in a vehicle unsupervised, unattended, resulting in great bodily harm, or as in this case, death. You're going to hear from a lot of different witnesses in this case, and this is what the evidence is going to show. On July 19th of 2023, Brooke Paige and Justice Paige, they are a young married couple, had a child by the name of Ariya. On July 19th of 2023, Ariya was basically 10 months old. Brooke's going to take the stand, and she's going to tell you that they had hired the defendant in this case to care for their child. Brooke works. She's going to tell you, I think she works at Blue Cross Blue Shield. Justice works as well. On July 19th of 2023, the defendant comes to Brooke and Justice's house, that's here in Baker County, to pick up Ariya. That was the arrangement that they had. Brooke's going to tell you that the defendant was the babysitter, the nanny. They had an agreement she would watch Ariya. She paid her to watch Ariya on certain days. So the defendant shows up at approximately 8 o'clock in the morning. When she arrives, Brooke already has Ariya in the car seat, the baby car seat, ready to go. She has a baby bag with certain items in it, the things you would expect in a baby bag. A baby bottle, baby food, baby formula, diapers to change your clothes, pacifier, things of that nature, things you would use to take care of a child. Brooke's going to testify that when the defendant arrived around 8 o'clock in the morning, that Brooke herself took Ariya, who's in the car seat, and puts her in the defendant's vehicle, which is outside. And she also puts the baby bag into the defendant's vehicle, and the defendant then leaves. And then Brooke goes to work, and Justice is already at work. The defendant, when she has Ariya in her vehicle, she leaves. She first stops at Burger King, the one right down here on 6th Street, to get something to eat. She goes through the drive-thru. The line is too long, she leaves. So then the defendant goes to Stacy Pascal's house, and Stacy Pascal is going to take the stand as well. She goes there because the defendant also watches Stacy's 3 kids. She has an agreement with her. She's a babysitter for her as well. She arrives at Stacy's house. The defendant gets out of the vehicle. When she gets out of the vehicle, she has her cell phone in her hand. She has a can of chicken. She has either a water bottle or a cup of water and a bag of chips. But the evidence is going to show that Ariya is still in the car. And the baby bag is still in the car. She goes into the house and talks to Stacy before Stacy goes to work. Brooke, the mother of Ariya, is going to tell you that at 8:17 that morning, it's only been maybe 15 minutes since the defendant left the house, but at 8:17 she gets a text message from the defendant. The text message basically says something to the effect of, and you'll see it, something like, she just left. She's basically informing Brooke that Stacy has now left the house. The important thing is the evidence is going to show that at 8:17, the defendant is having contact with Brooke Paige, the mother of Ariya. But Ariya is still in the car with the baby. At 8:32, a few minutes later, Brooke responds to the text message. And the defendant responds to that. That's at 8:32. Once again, the evidence is going to show that the defendant was communicating with Brooke Paige, the mother of Ariya, at 8:32. But Ariya is still in the car. And the baby bag is still in the car. So we go a little bit further. There's another witness that's going to take the stand. Her name is Nevaeh Carter. Nevaeh Carter is, I believe, 18 years of age. She is Brooke Paige's younger sister. She's also the aunt of Ariya. Nevaeh is going to tell you that the day before July 19th, her and her boyfriend had gone to, I think it was the Texas Roadhouse, and Nevaeh had taken a picture of her boyfriend eating dinner and put it on Snapchat. The reason this is important is because Nevaeh knows the defendant, and they communicate through Snapchat. Nevaeh is going to tell you that I think it was around 11:25 that morning, the defendant decided to respond to the picture she had posted the day before of her boyfriend eating dinner. The response that the defendant put, it was something like, "Hey cuties, Rhonda loves you." And Nevaeh will say that she responded back by putting like a heart emoji with like a cartoon picture of her face on it. This is the important thing. The evidence is going to show that around 11:25 in the morning, the defendant was communicating with Ariya's aunt. But Ariya is still in the car. And the baby bag is still in the car. Brooke's going to tell you when she's on the stand that she went to go pick up her daughter, Ariya, at around 1 o'clock that afternoon. That's when she would normally pick her up. She went to Stacy's house. Brooke's going to tell you that when she goes to pick up Ariya, she goes to the front door. That house has a back door. She doesn't go to the back door. She never does. It has a garage door. She doesn't go to the garage door because the garage door is closed. She goes to the front door. That's where she always goes. Brooke's going to tell you that she knocked on the front door. There was no answer. She can hear the TV on inside the house through the door, so she knows somebody's in there. She then rings the doorbell. There's no answer. She then decides to call the defendant and just says, "I'm here." The defendant then says, and Brooke will testify to this, "What door are you at?" Which Brooke will say seemed a bit strange because she always goes to the front door. And Brooke then tells the defendant, "I'm at the front door." At that moment, the door opens. The defendant is standing there. Brooke's going to tell you she walked into the house. She took her shoes off. She was planning on just talking to the defendant for a while. At the moment that Brooke takes her shoes off and she's in the house, she's going to tell you that the defendant started screaming, "Brooke, Brooke." And the defendant then runs out the front door, past Brooke, and she's running towards her own vehicle. The defendant had parked her vehicle outside on the gravel right beside the house, just outside. Brooke's going to tell you at this point she didn't know what was going on, but she decided just to follow the defendant. She didn't know why she was screaming. She follows the defendant to the defendant's car, and then she realizes Ariya is still in the car, in the back seat, strapped inside her baby seat, that she's been there now for over 5 hours. Brooke's going to tell you at that point, they get Ariya out of the car. It's the middle of July. She's extremely hot. They move her into the garage and put her on, I think there's a golf cart in the garage. They put her on top of the golf cart. Brooke calls 911, get the paramedics there. After she calls 911, she calls her mother-in-law, her husband's mom. Her name is Pamela Paige, and Pamela Paige will take the stand too. She calls Pamela Paige because Pamela Paige has been a nurse now for 31 years. She wants to know what to do. Pamela Paige, when she takes the stand, will tell you that she started, when she got the phone call, she was at Walmart, I think on 5th Street. She's at Walmart. When she gets the phone call and is being told that Ariya's lips are blue, she immediately starts telling Brooke how to do CPR. And she drops everything she has, runs out of the store, gets in her car, and she's driving towards the house. While she's driving towards the house, the paramedics arrive because 911 had already been called. The sheriff's office arrived. Paramedic Paul Dickinson and his other crew member, her name is Laura Lee Gonzalez, get out and they start performing CPR on Ariya. Brooke is already performing CPR, but they take over now. Paul Dickinson's going to take a stand. He's going to tell you that when they started performing CPR, that he and his second crew member realized pretty quickly that what they call rigor mortis had already set in. The child's body had gotten stiff. That's what happens when someone passes away, the muscles get stiff. So they quickly transport the child to Ed Frazier Hospital down the road. The fire chief, they arrive, Chief Blanton, his name is Donald Blanton. Chief Blanton is going to take the stand. He's going to tell you when he arrived, some time had passed. He'll testify to that, maybe 15, 20, 25 minutes. But he has a device, he's been with the fire department for like 30 years. He has a device that measures temperature, something the military even uses. He's going to tell you when he measured the temperature in the car, keep in mind, Ariya's not in the car. She's been transported to the hospital. The car door has been open for a while, so some of the heat has dissipated. He's going to tell you that when he measured it, it was 133 degrees. Then we go to the hospital. The family has gone to the hospital. The baby has been transported to the hospital. Dr. Aaron Ward then sees the baby and quickly realizes the baby, Ariya, is deceased and informs the family. There are several nurses there. One of them is a nurse, Charles Smith. He's going to take the stand. And he's going to tell you after they declared that Ariya was deceased, that the temperature of Ariya was taken. It was something that was requested by the medical examiner's office. And he's going to say the thermometer that they used, his understanding, he could be wrong, but he said, I don't think it went above, he'll tell you this, he doesn't think it went above 110 degrees. That was the maximum it would record. When they took the temperature of Ariya, it was 110 degrees. At that point, after she's been out of the car and transported by an ambulance to the ER. The medical examiner is going to take a stand. He's going to tell you that Ariya died from hyperthermia, her body overheated. He'll go into details about that. At the close of the case, the state is going to ask you to find the defendant guilty on all three counts. As I mentioned earlier, aggravated manslaughter of a child because the defendant engaged in a course of conduct that she knew or should have known, or any reasonable person would know that if you leave a child in the vehicle for 5 hours, the child's going to die. The state's going to prove to you that she had a duty to care for the child, to feed the child, to change the child's diapers, for bottles, use the baby lotion, the baby wipes, everything that was in there. We're going to show you through the evidence she didn't do any of that. She left the child in the car for 5 hours. So we're going to ask you to find her guilty on an aggravated manslaughter of a child. Also, the charge of leaving a child in a vehicle unattended, unsupervised, that results in great bodily harm, or as I said, in this case, death. The state's going to prove the child, Ariya, was left in the vehicle for over 15 minutes, over an hour, over 2 hours. It was for over 5 hours. We're going to ask you to find guilty on that. And the third charge is third-degree murder unpremeditated. We're not saying this is premeditated. We're saying third-degree murder unpremeditated during the course of a felony. And what the state means by that is we're going to show you, we're going to prove to you that the defendant committed the felony of leaving a child in a vehicle that resulted in great bodily harm, in this case, death. And that during the course of her committing that felony, the child, Ariya, died, which is a third-degree murder charge. So the state's going to ask you to find the defendant guilty on that as well, on all three counts. Thank you.
Mr. Nelson? may proceed.
Good morning. Wednesday, July 19, 2023 was a tragedy for the family of Ariya Paige. It was also a tragedy for Rhonda Jewell, a mother herself, and someone who loved Ariya Paige. I believe we heard testimony about the early morning hours of July 19, 2023, when Rhonda Jewell made the drive approximately 30 minutes from her home to the home of Brooke and Justice Paige. She had done this several times before. However, this particular morning was different. Mrs. Jewell had been caring for two 3-year-old twin boys and a 9-year-old girl at the home of Stacy Pascal. She'd been caring for them for about 4 or 5 months. On some occasions, the two twins were there. On some occasions, all 3 of them were there. You will hear from Miss Stacy Pascal, the mother of the 3 children, that she'd asked Miss Jewell, or told Miss Jewell, she needed to be there early that day. And Miss Jewell had called Brooke Paige and told her that, so she's going to pick up Ariya a little bit early. She needed to be at Miss Paschal's home by about 8:15. So Rhonda Jewell, based on that, spoke to Brooke Paige, made arrangements to be a little bit early. And as the state's indicated, the routine was that Brooke Paige would bring the child out, Ariya Paige out to the car, open the back door, place the child in the back seat, as she always did, and strap her in. You'll hear a little bit of testimony about the fact that this car carrier didn't have a seat latch or seat base in the car, so they took a seat belt. Brooke took a seat belt, just kind of strapped the child in, with the child still strapped into the baby carrier. Miss Jewell, you'll hear testimony that Rhonda Jewell proceeded to Miss Stacy Paschal's home. You will hear testimony that, normally speaking, Miss Jewell watched Stacy's children until about 5 every day when Stacy came home from work. Mrs. Jewell was in a hurry to get to Stacy's home to make sure she was there on time so Stacy could leave on time. On the way there, she thought about stopping at Burger King. We'll hear testimony about this, to get some food for the 3 kids. But the line was long, so she proceeded on to Stacy's home. She arrived at Stacy's home, parked in the usual spot that she did, which you will see from pictures and hear from testimony, is a gravel area off to the right of the driveway of Stacy Paschal's home. She went inside the garage door. There's a garage door itself and a side door. She went in there like she always did. Stacy Paschal had always told Rhonda Jewell, just knock on the door and then come on in. Stacy will say she heard Rhonda knocking. Rhonda came in. As the state's indicated, she came in with several items. You'll hear testimony that when she came in, she put those items down on the counter. Stacy Pascal engaged Rhonda Jewell in a brief conversation about one of her sons, who she wanted to check about an injury he had received the day before. The conversation was brief. Stacy went out to her car and left for work. It's important you'll hear testimony in this case that there were days when Rhonda Jewell had Ariya at her home, Rhonda Jewell's home, and days when she watched the twins and the 9-year-old daughter of Stacy, either at Stacy's home, and possibly had Ariya on some of those days. It wasn't a regular schedule. You'll hear testimony that about 1:15 in the afternoon, Brooke Paige arrived to pick up Ariya. She normally would leave her home about 1 when she took her lunch break, drive to Stacy's home, which is about 15 minutes, go to the front door, knock, pick up Ariya, and go back to her home. On July 19th, as this day is indicated, Brooke Paige will testify that she went to the front door and knocked and got no answer. She'll testify that she heard noises, TV, and her children playing or talking inside the home, so she rang the doorbell. We'll also hear testimony from Stacy Pascal. The doorbell wasn't working. So she calls Rhonda Jewell. Rhonda answers the phone. And Stacy Brooks says something to the effect, "I'm here." And Rhonda Jewell says, "What door are you at?" Again, Brooke Paige always came to the front door. You'll hear testimony at that point that Rhonda Jewell opened the front door and immediately pushed Brooke Paige aside, ran out the front door frantically screaming Brooke's name, and ran to the Tahoe parked on the rocks next to the driveway. You'll hear Brooke Paige say at first she didn't know what was happening. But when she saw Rhonda Jewell running to the car, she realized what must have happened. We heard testimony that Rhonda got to the Tahoe, opened the door, and there was Ariya Paige. You'll hear testimony, obviously, at this point, that both Rhonda Jewell and Brooke Paige were hysterical. You'll hear testimony about the next few minutes where a 911 call was made, where Rhonda Jewell took Ariya out of the car, held her, took her into the garage, and laid her on the seat of a golf cart that was there. You'll hear testimony that when Brooke called 911, she wasn't really sure what the address she was at, Stacy's address. So she asked Rhonda Jewell to go out by the road and make sure the ambulance and rescue came to the right home, which is what Rhonda Jewell did. Tragically, however, Ariya Paige had been deceased for some time. Again, you will likely hear testimony about how distraught, obviously, Brooke Paige was, and how distraught Rhonda Jewell was. You will hear testimony about Rhonda Jewell screaming. You'll hear testimony about Rhonda Jewell throwing up in the bushes and dry heaving. You'll hear testimony about Rhonda Jewell urinating on herself. Likely, we'll hear some testimony about things Rhonda Jewell said after the police arrived, even before the police arrived. You'll also almost certainly see an interview of Rhonda Jewell that lasts about 7.5 minutes when she was interrogated about an hour later at the sheriff's office. Some of that testimony, some of the evidence may not come out initially in the state's case. It may come out in the defense case or later on. I'd ask you again to listen to all that before you make a final decision. The state's told you that they believe, from their view of the facts, that they will have proven to you that Rhonda Jewell is guilty beyond a reasonable doubt at the end of this case. That's what they certainly will ask you to do. I would ask you to remember that you are not to form any fixed opinions about this case until you've heard all the testimony, seen all the exhibits, and been instructed on the law. This was a tragedy. No one would ever dispute that. Accidents happen. Good people can forget things. Sometimes the outcome of that is just absolutely catastrophic. I ask you to keep in mind that the law in this case defines what a crime is and what a crime is not, and the judge will read you those instructions. You must determine yourself which facts you put the greatest weight in or which facts you don't. That is your job. You were charged with the task of applying the law, whatever it is, even if you don't like it, to those facts. and you're required to give Rhonda Jewell the presumption of innocence as the judge will instruct you. You also are required to hold the state of Florida to their burden of proof in this case.
Your Honor, we could approach briefly.
Yes.
I ask you to hold the state to its burden of proof that the judge will detail for you. That you hold the state to the law that requires the state prove this case beyond a reasonable doubt. I believe at the end of this case, the state will have failed to provide you sufficient evidence consistent with the law which finds Rhonda Jewell guilty. Thank you for your time.